right, we'll get started. Thank you again for joining us. This is the ASC Presidential Panel, the first one this ASC meeting. My name is Andres Rengifo. I'm a professor in the School of Criminal Justice at Rutgers. Welcome. I'm delighted to have here a wonderful roster of panelists. I will be introducing them as we go along. Thank you to our president for setting up and allowing us to be here, and to the organizing committee. Thank you for this opportunity. This panel examines the challenges and opportunities in research and policymaking related to crime and justice in Latin America. As the region continues to confront persistently high levels of crime and violence, governments and civil society have adopted innovative strategies for peace, justice, and recovery. These approaches, ranging from restorative to transitional justice models, seek to complement or even replace repressive, tough-on-crime policies. So part of what this panel is about that balance and whether we actually learn something from that contrast. Our first presentation is by Julieta Lemaitre, who is a lawyer, a Colombian lawyer. She has an MA in Gender and Religious Studies from NYU and a doctoral degree in law from Harvard. She's one of the 38 magistrates of Colombia's Special Jurisdiction for Peace, where she leads the investigation and prosecution of FARC-EP's ex-commanders for war crimes and crimes against humanity. Julieta, it's a wonderful honor to have you here.
Hi, thanks for having me. It's great to be here. I used to be a professor before joining the Special Jurisdiction for Peace, and it's always a pleasure to be back with you guys. And I can tell from the room, the alternatives to mano dura are not incredibly popular. Yeah, that makes sense. So I work at the Special Jurisdiction for Peace. As you can see in the backdrop for the presentation, there's 38 of us. It's an actual jurisdiction, so it has a series of chambers or panels, and I'm in the entry point to the jurisdiction. It's called the chamber or the panel for the recognition, for the acknowledgement of responsibility and the recognition of truth. Basically, the jurisdiction offers two different processes for people who participated in war crimes and crimes against humanity during Colombia's protracted internal armed conflict. They can either accept the charges and be remanded straight to sentencing, and the procedure we use there is we call it the dialogic procedure, but it's basically an adaptation of restorative justice. Or they can reject the charges and be remanded to a regular trial. And to the point, we've been working since 2018. 80% of the former military, and up to this point, 100% of the former insurgency has accepted the charges. The panel where I sit writes up those charges and charges them with war crimes and crimes against humanity. And today I want to talk a bit about that dialogic procedure, what we've learned from restorative justice, how we've adapted it, and the challenges and ethical dilemmas it presents. And you'll also see, maybe it's not that clear there, but half of us are women, and there's a proportional representation of indigenous peoples and Afro-Colombians, which is really unusual for a court in Colombia. So we're basically representative of the country, but not just in terms of gender and race, but also in terms of regional origin. Colombia is a country of regions. And also of personal trajectories. So some of us come from human rights practice, some of us come from criminal law practice. Myself and a couple of other colleagues come from academia, and the diversity of professional trajectories sort of ensures more or less also a variety of ideological approaches to criminal law, which makes it hard to work with. So next slide, and I'm just wondering, what do I press here for the next slide? It's not really, okay. Okay. So the first thing we do is listen to perpetrators. which is already unusual in international criminal law. In that image, you'll see the voluntary versions, that's what those hearings are called, where we've been hearing recently Julian Gallo and Rodrigo Londoño of the former FARC Secretariat for massacres and attacks with explosive against civilians. We listen extensively to perpetrators. That's unusual in international criminal lawyers. Actually, the literature points out to that deficiency where perpetrators are very rarely heard. Mostly it's their defense lawyers who do the speaking, and when perpetrators talk, they're sort of scripted by their defense lawyers. We've adapted the British peace method that was also recommended in several instances of the United Nations as a method of interrogation. And it's sort of modeled also on semi-structured interviews in the social sciences with some input from psychologists using also therapeutic methods for talk therapy. So we have them talk for days at a time. We ask a lot of questions, and there's a lot of feedback. So it's listening to perpetrators, but not just listening, but engaging in a dialogue. There's some tropes of that dialogue that I want to point out. One trope is that it's hard to understand what's going on through the din or the fog of war. So we understand that, and we have them talk about that. What can you actually realize of what's going on when you're in the war itself, in terms of the crimes, of course. We also talk a lot about what it means to perpetrate war crimes and crimes against humanity when you're part of a system or of an army. The mode of liability that we use is perpetration through an organized apparatus or superior responsibility. So we talk a lot about those elements, about how do you give orders, how do you receive orders, how do you obey orders. There's a lot of that. We insist on treating perpetrators as human beings. Most of them do not have any form of mental illness. The crimes they committed it as normal human beings and healthy human beings, which means that most of them do have a sense of morality and the capacity of empathy that we appeal to, mostly by reconstructing the memory of what motivated them to get into an army, to serve their country, the bonds of loyalty and affection that tie soldiers together. There's a lot of morality there that they themselves can evaluate as having been lost along the way as they committed crimes. So we appeal to that as a way to establish this dialogue. We insist on naming what they did as crimes. We recognize that they themselves were hurt by committing crimes with the ideas of moral injury and perpetrator trauma. There's a whole literature on that, but it's also very real and it comes out in the dialogue. We expect that they acknowledge the harm they caused as part of their acknowledgement. We expect them to identify individual victims who require that by name and face and what happened to them. And it is their duty to assimilate what happened to their victims. And we structure the whole thing on the idea that there are two moral moments. There's a moral moment when they committed the crimes, but this is a separate moral moment where they are called upon to acknowledge what they did. And it's for them to do so or not, but it's a separate moment with its whole ethical burden. And we do understand reincorporation into society as part of the proceedings. These are all men who are in the process of reincorporating back into society, and that's also part of the dialogue and certainly one of the issues that we bring up in these dialogues. Afterwards, we listen to victims. So there's another session of hearings called victim observations, because the previous hearings where it's just us and the perpetrators are taped and then they're shown to victims. And this is an image of one of the victims, her mother. It's a mother of a young man who was executed and falsely passed off as a death in combat. And we have different cases and a wide variety of victims. and we listen to them. They're also supported by psychosocial professionals. You know, Latin America has this whole tradition of psychosocial professionals who respond to victims and support victims of political crimes. And so they have a process where they're being not treated in terms of therapy, they're just being supported so they can tell the judge what they want to say and be clear about it and manage their emotions. In these hearings of the victims, there's also a series of tropes. We tell them frequently that we believe them, which we do. Mostly because once you start hearing victims, there's a repetition. We work with patterns of crimes. So it's different people, but they have gone through very similar forms of victimization. So we also tell them that, and they listen to each other and start to understand what happened to them as a pattern, as something that happened massively during the war. We do a lot of empathic listening. We get training for empathic listening that's similar to what therapists do. We understand that sometimes victims are not very verbal, but their demeanor, the way they display their emotions is a form of communication, so we respond to that as well. We insist that they're part of a community of people who were victimized. We insist that they are speaking also for those who cannot speak, who suffered similar forms of victimization. We insist in naming what happened as a crime, as a crime of war, a crime against humanity, or both. And the way we treat them, we also understand that it repairs a past where the state was oblivious to what was going on, or indifferent, or complicit in the crimes. And we also insist that these are people who have survived what happened, that the crimes are in the past and they're not happening 20 years later. And we try to place their narrative in time, which this was insisted on by the psychosocial support to help people live through their testimony without reliving what happened, but knowing that this is a testimony 20 years later in a court. It's a different moment from the moment. So there's a lot of tropes that bring that back to the discussion. And then comes the moment of acknowledgement. If they accept the charges, then there's a hearing where they finally meet, perpetrators and victims. And mostly they meet with those most responsible, with the commanders or the military superiors. And I just want to show you 2 minutes of what that looks like, because it's hard to describe, and I'll finish with that.
Con dolor en el alma, venimos a esta audiencia a reconocer, y estamos ante ustedes reconociendo que a nombre de ideas revolucionarias cometimos estos crímenes de lesa humanidad y crímenes de guerra.
La mayoría de los relatos de las víctimas da cuenta de un trato violatorio de la dignidad humana en la cotidianidad, sufriendo distintos vejámenes, insultos, empujones, golpes, gritos, amenazas constantes.
My time is up. I wanted to show you more of the dialogue between the victims and the perpetrators. It's on YouTube if you want to Google it. It's got, this clip has the subtitles in English, but there's an exchange that can be very emotional. People get angry, they get sad, and it happens before a public that also sometimes interpolates what's happening. We've been doing this for the last 6 years now. It's really powerful, but it's also emotionally and ethically challenging for us as the operators of the system. And I'll just end with 3 ideas of what I consider to be the most difficult challenges. The first one is that what undergirds the whole design is forgiveness. In a sense, these men are like in the Christian parable, the prodigal son. They are returning to society, and this is the way that we're receiving them. But forgiveness is a gift. It's freely given. It can't be forced, and it can't be forced either in individual victims or in a society as a whole. So that's always a challenge. There's a conceptual tension between the idea of forgiveness and the idea of justice that I won't go into, but it's experienced every day when you're at work. And I do believe that reconciliation after civil strife is a political responsibility, and it's a political responsibility of the state. So there's a tension between that duty to build reconciliation and the difficulty of forgiveness and the difference between forgiveness and justice. And that's, I think, at the heart of the ethical challenge of doing this. Thank you very much.
Thank you very much. For our second presentation, we have Negotiating with Organized Crime in Colombia, Legal, Political, and Social Dilemmas. Miguel Larrota is presenting for the team at the Laboratorio de Justicia y Política Criminal, a regional think tank based in Colombia. Miguel is a lawyer. He has an MA Public Policy and a Master's in Criminology from Oxford. Thank you.
And thank you for having me here. Let me start by describing who we are. We are new, and we have 5 years, a think tank and a do tank that dedicated to transforming justice and criminal justice policy. And we promote institutional change, working with public authorities through strategic reforms, organizational adjustments, and operational level interventions. In 2022, Colombia became the first country in Latin America to openly and formally enter negotiations with criminal organizations in Colombia, comparing to armed groups in conflict or political groups in international or non-international conflicts. The government entered with Law 2272 into negotiations with many, like 8 tables of criminal organizations dedicated to illegal mining, to drug trafficking, to extortion. So we did field work in 4 cities, 2 urban and 2 rural cities, and we asked ourselves what the role of the legal framework was for these negotiations, what the legal framework enabled. Did the legal framework enable or hinder these negotiations? And this is very important in Colombia because, as we're going to see, the legal framework was essential for the continuation and the conclusion of negotiations against, with these groups in Colombia, comparing to other countries in which the legal framework is not as central to the conclusion of negotiations. Even if these negotiations are not public, there are a lot of documented examples of these negotiations from Belize to Trinidad and Tobago. In these negotiations, truces, disarmaments, demobilizations are negotiated, also the legalization or the transition to cultural associations from gangs. There's a whole set, very ample set of negotiations. And this has been studied in the world, in Europe, in Anglo-American countries by Freeman and Felba Brown from the Institute for International Transitions, international transitions, and also for Latin America by Duran Martinez and Cruz. Maybe the negotiations start by diminishing the homicide rates, no? So they are in the short term successful in diminishing violence in terms of homicides, but some of these negotiations at the end in the long term fail because of some reasons detected or by the authors. For example, in Ecuador, in Belize, and in Medellin in 1994, the long-term success depended on clear initiatives, on legitimate mediation, community support, and a credible state pressure. And on the contrary, the examples are also Belize, El Salvador, or Trinidad and Tobago. Failures in the long term were due, according to the authors, to lack of transparency, weak institutional backing, and unsustainable agreements, politically speaking. What we did is that we studied 2 urban cities and 2 rural cities. These negotiations were with groups that were a mix of local gang members and also former members of rebel and paramilitary groups. They exhibited elements of criminal governance like extortion, the implementation of violent repertories to control territories, and also the implementation of informal dispute resolution mechanisms on the ground. For these negotiations, for these 4 contexts, violence, or at least homicide, reduced from 2022, but it fluctuated alongside progress and setbacks in the negotiation process. As the negotiations, for example, entered crisis, the homicide rate started increasing again for some of these tables. And through these studies, we concluded some types of challenges. And challenges taking into account that this attempt of total peace negotiations has been largely unsuccessful. From at least 8 negotiations of total peace attempts, only 2 have advanced and shown substantial progress. The first challenge is the legal framework, as I was describing. There is a centralized framework from Law 2072 to enter negotiations, but there is no unified legal framework for submission to justice, for deciding how to punish the people that are trying to demobilize collectively. No? And these legal gaps hinder closure of negotiation tables. Members of criminal organizations can enter the negotiation, but at some point they say, I don't have enough incentives to stay in these negotiations or to demobilize. And we analyzed the existing tools, the existing benefits that the criminal codes offer in Colombia, and these are insufficient to incentivize demobilization. A leader from one of these groups can be sentenced to 60 years, and with all this, like accumulating all the possible benefits, they would effectively pay a prison term of 17 and 20 years, which is insufficient for them to demobilize. A second type of challenge is the territorial and political, it has to do with the territorial and political dynamics. First, there is a centralized policy for negotiations, but at the end, the content of the negotiations is very local, with groups that are very, very territorially, that are very local. So there is a limit to how these negotiations can coordinate and adapt to the local framework. No? Second, the victims and the communities expect reparations. You know, these victims that the communities having, for example, suffered extortion massively for the last years by these groups, and it is not evident from these negotiations that reparations will be effective. There is a cost and benefit of extradition treaties from Colombia to the US. On the one side, strategically, extradition can be a leverage for negotiations for the government, but on the other side, some types of arrest asked for by the US can hinder negotiations. And naturally, even if there is local support for some of the negotiations, that's what we qualitatively have seen in localities like Buenaventura, like Tumaco, like Quibdó. Nationally, these negotiations are very unpopular. The last national survey that we saw had that 60% of the people rejected these negotiations. So politically, it is very difficult. The third type of challenge is the capacity traps. No? The capacity traps of the judicial system. First, the prosecutors, the judicial investigators, and judges have lacked the methodological and the strategic tools to investigate and prosecute complex cases, to build macro investigations, to understand groups, the behavior and the patterns of the behavior of the groups in order to incentivize collective submissions. No? There is also a low institutional capacity to identify and to monetize organized crime asset reparations. No? There are very large units that investigate financial crimes, but they don't have the capacity also to build complex cases. No? And the formal justice mechanisms coexist, no? In many areas in Colombia, urban and rural areas in Colombia, with informal community justice practices, which is okay, but also coexist with dispute resolution tools from criminal groups. So there's a competition there that it's not easy to deal with. And our conclusions are that negotiations are an option. They're a valid option to control very violent contexts. They're a valid option to understand that states in Latin America have to coexist with illegality in some contexts and to choose and prioritize the worst damages of those illegalities. But they're not a goal in itself, and sometimes these type of negotiations become a goal in themselves. So they should remain viable, but within a broader security, within broader security objectives, and be very careful, monitored for the long-term effects. And also that there is a need of a legal framework that provides incentives for the judicial transition, but a legal framework that tries to balance between the incentives produced for the group's members, but also take into account the political justice demands, both nationally and locally. And finally, that further research is needed on the impact of legal frameworks in the negotiations outcomes. Thank you.
Thank you.
As you guys have probably noticed, we started with Colombia. We are opening that Colombian focus to think more about the region. And so the third panel, the third presentation is from Ana Daza on the Colombia and the United States, a common fight against drugs and crime, results and challenges. Ana is an external affairs counselor at the Colombian Embassy here in the United States. She has over 30 years of experience analyzing and intervening in humanitarian and other complex situations. Ana, thank you.
Hello, everyone, and thank you for your time, actually your lunchtime, and your attention to these matters that are so interesting for us, and especially hearing about Colombia. That's our main interest in the embassy, to talk about what, as a country, what we're living, what are the intersections, the voids, and the opportunities to tackle matters that are so highly affecting us, as are the drug trafficking issues and the transnational crime. First, I want to remember you that Colombia is a very particular country. We have a lot of borders. We have 2 land borders with Brazil and Peru. We share land and sea borders with another 3 countries, Ecuador, Panama, and Venezuela, and we have 6 sea borders. This is something that we tend to forget. That means we have a border with Haiti, that we have a border with Honduras, with the Dominican Republic. So this is like a perfect situation for somebody who wants to gain through crime. You know, if we tend to make a simile with what happened during the Prohibition era, where you had gains if you passed the border between different states. Now imagine here, having all these borders. Of course, this is all actually an opportunity, because from Colombia, we can affect a lot of countries. There's no other country in the region that has so many borders. So yeah, it's an opportunity too, and something to tackle. We have been, during 46 years, doing work with the United States trying to control the drug traffic issue. We started in the late 70s with the extradition treaty that, even though it's not formally going on, every day, every 12 hours, a Colombian comes to the United soil to being extradited and to answer to justice. No other country in the world sends so many nationals abroad. During the 90s, we did 2 dismantling of cartels. If we go from that time to now, we can talk about 4 kind of cartels, and now the dynamic is different. Since early 90s, we have had some kind of trade pacts to tackle the first part of the production chain. We had Plan Colombia, Peace Colombia, and since 2020, the Western Hemisphere Drug Policy Commission. So what we have is this. You can see that arrow shows how the criminal groups have more gains. The least gain is at the crop level. But during these 46 years, it's where we have invested most of the policies and the different kind of justice systems. We have tried to do aerial spraying, manual spraying, all kind of projects of development, strengthening the law enforcement in the territories, arrests. We have had all kinds of forfeitures, gasoline control, controlling of the armed groups, peace with the armed groups. All this has been happening in the crop level, right? Then we go to the next level. That's when you have paste that needs some kind of processing. And then you have a third level where you have the crystals. So regarding the paste, we have also done lots of efforts, controlling the precursors, controlling the burning and destroying this kind of infrastructure that is very basic. It's more like an encampment. And then we have the third level of the crystal. There we have done a lot too. Sometimes our figures mix those 2 kinds of laboratories, but they're very different. And the first one, you don't need great investments. And the second one, you need electricity. You need microwave ovens. You need a lot of water. You need to be near a river so that you can, use it for the processing. So here, we have a great opportunity to do more. Then we have the transportation. That has to be taken to a place to make use of all these opportunities of our borders. Since the first beginning of the drug trade, it has been an export product. So you have to get to the border, and then you go to the sea. There is the greatest investment. There is where now the current government is investing in interdiction, in intelligence, trying to control money laundering, because in that phase is where the criminal groups lose more. You know, in the first one, the ones that lose are the peasants. And many of those peasants just don't have any other opportunity than to work on those kind of economies. Here we have something that has been done with the crops since the beginning of this war, that it's eradication. So you see eradication and you see substitution. Even though we have been doing substitution since the beginning, it has not been monitored in the same way that has been monitored eradication. So we have UNODC, you know, having all these satellite images and seeing how eradication goes, but not substitution. What is substitution? It's when you change one crop for another. As you see, in the recent years, there has been almost no eradication because it was done by aerial, using spraying using glyphosate? Yeah, glyphosate. So now we're doing more substitution. What we have there is, in Colombia, there are 32 departments. During this long period that started in the early 2000s, what we see is that we had a lot of departments with cocaine, and now we only have 14. So what we have now is concentrated crops in a form of enclave, and there you have other kind of problems, more violent governance, as my predecessor was talking about. Here you have another thing. Who does the crop control? Who guarantees, you know, that it gets to the border? It usually is, since it's an illegal economy, it's an illegal group. And it uses arms because it has to defend, you know, the commodity and all the investment. What you see here is what the peace processes have done. You see that if you look at the indicators of violence regarding armed conflict, not regarding urban security, not regarding, you know, crime, common crime, you see that they have gone down. Even though we have new kidnapping, it doesn't compare to what was before the peace processes. There's a before and after. Even though we have some security problems, it's a different kind of violence, what we are experiencing now. We have learned some things with all these decades of fighting crops and especially the first part of the cocaine trade. The aerial spraying are effective in the long run. If you do that, the crop just moves on or comes back. If you have people that really want to change that does, you know, that brings a lasting result. So we have to involve local farmers. And one of the things that has been key is that when they become landowners. When people own the land, they do not use illegal crops because they can lose the land. You know, it can be forfeited. So this has been very important. It has been an innovation that has worked. Now it has stopped because we received a lot of help from the USAID for that kind of actions. Engaging with local leaders builds effective solutions and their communities. Of course, this has some trouble because then the armed groups are going to attack these leaders. So it means it needs another kind of protection and other kind of actions. Targeting criminal organizations at the laboratories, this is the crystal ones, not exactly the paste, the coca base. Precursors and drug shipments, this produces a greater impact. This really hurts their benefits, their profits. And finally, coca is not cocaine. And the peasants are not narco-traffickers. Okay. So now, of course, when we have all these borders, whatever we do in this part of the chain of the productive and value chain, that is the last one, has to involve other countries. So we have operations like this one, Orion, that has been going for some decades now, where 64 countries participate, and we do interdiction. We have never done so much interdiction as during this past 4 years. Now, people say, oh, but production has grown. Yeah, but interdiction means you go out for the production. It's not that it falls on your hands, that you're there at the sea, and then you find cocaine, you know, there. No, you have to go for it. You have to do intelligence for it. It's a great effort. We have more results in interdiction now because we're better doing it, not because there's more cocaine, going down the street. We are doing interdiction near our coasts. As you see, it's more here near Colombia and the Caribbean than in the ports of destination. We are also, while we attack these criminal groups, we go into other kind of criminal activities that their portfolio has. You find human trafficking, you find smuggling, you find weapon trafficking. That they can just change their portfolio. They're like a logistic operator, so yeah. When we get them in the last part of the chain, they lose almost 90% of their investment. While if we concentrate in the crops, they only lose 5%. So this is what has been going on. It doesn't mean that we don't have to work with the crops, of course. We have to change, but with the communities so that it's for long-standing change. Current challenges, we have this problem, that is that the cocaine demand is growing. And it's growing more in Europe than the United States, actually. That's why last week in Santa Marta, we were talking about how can we prosecute better? How can we do better intelligence to avoid all the cocaine getting into Europe and, of course, in the United States? And we have this particular event. Now it's getting connected with other kind of profits. We have serious problems with cryptocurrency and with other forms of smuggling because it serves, to do this washing of profits, and there we need some innovative ways of pursuing. Okay, that's basically what we wanted to say. There's a lot to do, a lot to improve, but we are every day trying to control drug trafficking and criminal organizations. Thank you.
Thank you very much. Next, we have a presentation from Katia Salazar. Katia is a Peruvian lawyer with an MA in International Public Law, and is the author of various articles on topics related to human rights law and transitional justice. She, since 2009, has served as the executive director of Due Process at the Due Process of the Law Foundation. Thank you, Katia. She will be speaking about El Salvador War on Gangs. Thank you.
Thank you very much for the invitation. It's an honor being here. I represent the Due Process of Law Foundation, which is a regional organization working on human rights and the rule of law in Latin America. We have our headquarters here in Washington, D.C., but we have representatives in different countries in the region. And El Salvador was a special country for us because the organization was founded by the former members of the UN-backed Truth Commission for El Salvador, Professor Thomas Burgenthal and other members. When they finished their work in El Salvador and prepared the report published by the Truth Commission, they realized that the key role that the judiciary of El Salvador played or didn't play during the civil war, and this is why they decided to create an organization with a mandate to promote more independent and efficient judiciaries in the region. Our mandate has been shaped by the different directors that DPLF had, and since I am the director, I've been trying to do or to promote that DPLF works as a human rights organization in the region, working in hand-to-hand with other groups. For me, for this reason, it's very important to be here to talk a little bit about the situation in El Salvador. It's an important moment for El Salvador because we know that this country is going through somehow progress. We have better numbers in terms of security, and that communities there are experiencing a sense of safety that was unthinkable just a few years ago. But on the other hand, behind those numbers and headlines about the improvements in El Salvador, there are tens of thousands of people, including families, parents, children, whose lives have been profoundly affected by the state of exception and the measures taken by President Nayib Bukele. So I want to present today a brief summary about the current situation in El Salvador under the state of exception, and I want to also share with you an idea, a proposal, we call it expert commission, to review the cases of people detained under this extraordinary policy. To start, to start on the same page, for decades, El Salvador lived under the weight of gang violence. Criminal groups control neighborhoods through fear, extortion, killings, the recruitment of children, and sexual violence. Thousands of people were forced to flee their homes, to come here or other countries in the region. In March of 2022, after a surge of murders, the government declared a state of exception, giving new powers to the police and military to confront the gangs. That measure has been renewed over and over for more like 3 years. During this time, several fundamental rights have been suspended, including the right to a legal defense, including the right to know why you have been detained, including the right to communicate with a lawyer. The result has been a massive wave of arrests. Official figures speak of around 90,000 people detained since 2022, and among them, it's estimated there are more than 2,000 minors, and at least 400 individuals have died while in custody without clear explanations. Most of those arrested have been accused of belonging to a gang, yet the evidence is often extremely weak. Sometimes just an anonymous tip to the police has been enough to detain a person. A reform passed during the state of exception allows for indefinite preventive detention, meaning that thousands of people remain in prison without trial, without sentence, and without knowing when their case will be heard. Meanwhile, the judicial system is collapsed, of course, 90,000 cases. Just 20 to 30 specialized judges are in charge of these cases, supported by roughly 300 prosecutors and public defenders. At the same time, there is a concentration of power in El Salvador. As you may know, 3 years ago, the government, the president of Nayib Bukele, fired the general prosecutor, fired the members of the Constitutional Court in El Salvador, and the Congress appointed new members close to the administration. One example, during the state of exception, the Supreme Court has rejected the vast majority of habeas corpus petitions, leaving thousands of families unable to seek justice for their families. Well, now there is no question that these policies have improved public security, but they have also come with a very human and democratic cost. Human rights organizations, including DPLF, we have documented arbitrary detentions, torture, enforced disappearances, sexual abuse, and death in custody. 2 days ago, Cristosal and Human Rights Watch published a report on the Venezuelans who were detained in Secot, sent from the United States to El Salvador and detained in Secot. Some of these acts may even amount to crimes against humanity, given their widespread and systemic nature. And the president himself has recognized that several innocent people were detained. I think it was like last year, at the end of last year, that Bukele recognized that there were, among these 90,000 people detained, there were 8,000 innocent people, but he has already freed these people. So he recognized there are a lot of innocent people detained. From different perspectives, this is an unsustainable situation. From a legal perspective, the prolonged state of exception weakens several principles of democracy, the presumption of innocence, judicial independence, and the rule of law. From an economic point of view, the cost of mass incarceration is enormous. now this cost has been passed to the families of the detainees who have been asked for money, for food, for clothes, etc. It also removes tens of thousands of young people, many from already poor communities, from the workforce. And socially, the toll is also very high. There are pregnant women, elderly people, and individuals with chronic and terminal illnesses behind bars. Entire families have been broken apart. Children are growing up without parents. Ironically, the communities once terrorized by gangs are now the ones suffering the most from arbitrary detentions and stigma. To confront this situation, we have different avenues, different possibilities. One, of course, is accountability measures. No, we are also, we are working on this avenue, promoting accountability before international and regional human rights bodies. But there is also another avenue, which is like trying to help the government to face this reality. It is impossible, it is unsustainable to have 90,000 people detained without sentence forever. It's a lot of money that if the state doesn't cover will be passed to the families, and it's not human. I mean, you cannot have 90,000 people, again, forever in prison. So, in order to respond to this reality, and besides promoting accountability measures, we have been talking to different people to think in, how can we also help the government to handle with this situation? And we arrived to one proposal, which is the creation of an expert commission that can review this backlog, these 90,000 cases, not to analyze case by case and decide if the person is innocent or not, but it would be an expert commission to revise, to analyze the backlog, the cases as a whole, and to give recommendations to the government of El Salvador, to the justice system, to handle these 90,000 cases with, for example, criteria of prioritization and selection criteria, like, mirroring what is happening or what has happened in Colombia, no? This experts commission, the idea, or what we think, it should be ideal to, to create this commission, to select the members from experts in national and international law. It would be important that this commission dialogue with the justice system, and together to prepare like a list of proposals for the justice system to handle these cases. Believe it or not, there is not a register so far with the names of all people detained, their situations, their health situation. There is no list. So the first step that this commission should carry out would be preparing this register where all the information about the people in prison could be, and to help decide what could be this prioritization and selection criteria. Of course, humanitarian reason would be important. ¿Cuánto tengo? Sorry. Of course, humanitarian reason would be very important, but there are other criteria that could be used, like, for example, cases where originated in just a call, an anonymous call to the police, cases where there is already a freedom decision and the freedom decision hasn't been carried out, etc., etc. I think it is possible to have accountability for those gang members, but also justice. It is possible, and we need to think creatively and out of the box to propose, no? To think in this kind of proposals to face the current situation in El Salvador.
Thank you very much. And now to put it all together. Thank you. So we have Professor Susana Sakoto. She currently directs the War Crimes Research Office of the Washington College of Law at American University, where she also teaches courses on international criminal law and procedure. She'll be presenting on balancing global and local justice, the International Criminal Court, and Latin American domestic efforts.
Thank you so much for the invitation to be here and for joining this amazing panel of speakers. My remarks, as was just said, will focus on the International Criminal Court and its role in Latin America, focusing on the interplay between some of these domestic efforts that we've talked about and international justice efforts. I'm going to start by talking a little bit about the role of Latin America in the establishment and the support of the International Criminal Court. 28 of the 125 state parties to the Rome Statute establishing the International Criminal Court are from the Latin American region. And despite this very, very strong representation, the court has opened a formal investigation in only one country in the region, and that is Venezuela. The limited engagement, in some ways, raises important questions about how the ICC responds to situations in Latin America and what those responses mean for domestic efforts to pursue justice for ICC-type crimes like war crimes and crimes against humanity. So let me start with a few words about the open investigation, the open formal investigation in Venezuela. The investigation opened in 2021, and it concerns alleged crimes against humanity committed during the widespread protests and repression under President Maduro. The investigation stems actually from an interesting referral. In 2018, 6 states from the region, then later joined by 2 others, made a referral to the ICC to investigate the situation. And actually that referral marks one of the first instances where states have actually referred another state for investigation by the ICC. Earlier situations under investigation by the ICC were the result of what are commonly known as self-referrals, or when states refer their own situations to the court. Or by UN Security Council referrals, or by the prosecutor taking initiating the investigation on his or her own initiative. So this was out of the realm of the usual. Interestingly, the prosecutor's announcement opening that investigation was accompanied by an agreement with the government to promote domestic proceedings while also sort of strengthening cooperation in support of his work. 6 months later, Venezuela requested a pause in the ICC's investigation efforts to conduct its own proceedings at home. In response, however, the ICC determined that Venezuela's domestic efforts were inadequate. And they were inadequate for various reasons. They targeted only low-level perpetrators, and they failed to address this broader kind of contextual element necessary to classify crimes as crimes against humanity. And so the decision marked a significant moment for the region. It signaled, on the one hand, that the ICC was willing to intervene in Latin American contexts when domestic systems fell short. But on the other hand, the investigation has produced mixed outcomes. On the one hand, it's validated victims and civil society actors advocating for intervention, offering some hope for accountability. On the other hand, there have been some challenges, right? The prosecutor has had to recuse himself due to a conflict of interest controversy. No arrest warrants have yet been issued, and that has fueled frustration among civil society and victims groups. The investigation has also triggered political resistance. Some of you might have heard that Venezuela not only sought to halt proceedings, but also requested an inquiry by the ICC into alleged crimes linked to, quote, unlawful coercive measures adopted unilaterally by the US. So the case illustrates the ICC's potential to deliver justice for crimes in Venezuela, but also that very real practical constraints and political resistance remain significant obstacles. Now, despite requests for ICC involvement in other situations in the region, the court has declined. And I'll spend the rest of my remarks explaining why, using 3 examples to show how difficult it can be to strike a balance between global and local justice efforts. So first, in Mexico, the ICC has declined to open what's known as a preliminary examination. And that's a step before a formal investigation where the prosecutor assesses jurisdiction and admissibility questions. It declined despite repeated requests from NGOs and human rights groups alleging that widespread killings, enforced disappearances, and torture were linked to both state actors and cartels, and that violence could amount to ICC crimes like crimes against humanity, much like what Katja just spoke about in El Salvador. The response has been deeply disheartening for victims and advocates, especially given the widespread violence and systemic impunity surrounding the fight against organized crime. Rather than motivating domestic actors to build stronger cases, the ICC's silence may reinforce a sense of abandonment, frankly, and skepticism about the court's relevance to Latin American struggles. In countries like Mexico, where violence is often linked to state and non-state actors, the lack of ICC engagement can be interpreted as a failure to recognize the gravity and complexity of the situation. In other cases, the ICC has, in fact, opened a preliminary examination, but then declined to intervene because allegations were deemed insufficient to warrant that more formal investigation. And Honduras is one of these examples. There, the ICC opened a preliminary examination in 2010 following the June 2009 military coup, and it was focused on crimes committed by the de facto regime against the supporters of ousted President Zelaya. And the focus was both on the coup, but also in the post-election period. However, the prosecutor closed that preliminary examination about 5 years later because it found that the information it had was insufficient to conclude that those acts were committed as part of an attack carried out in pursuant or in furtherance of a state policy to commit an attack. And that's an essential element of the definition of crimes against humanity under the Rome Statute. So what happened there is the prosecutor concluded that yes, serious human rights violations had occurred, but those acts reflected, quote, more of an aggregate of random acts appearing to stem from the context of chronic and general violence in Honduras rather than a targeted attack against a civilian population. So while, again, we see some mixed results here, while the decision maybe added some clarity to how the ICC interprets the definition of crimes against humanity, clarifying that it is in fact a high bar, the decision also led some victims and civil society actors to feel pretty abandoned or discredited, especially after investing significant effort in documenting abuses and submitting communications to the court. Rather than encouraging stronger documentation, the ICC's decision may actually discourage future engagement, reinforcing perceptions that the court is inaccessible or overly selective. And I think what we see is that that can actually have impacts at home. It can weaken domestic demand for accountability, especially in contexts where national institutions are fragile or compromised. And in fact, to date, Honduras' accountability for post-coup crimes in Honduras remains pretty elusive. Widespread impunity prevails till the present day. In a third case, the ICC has declined to intervene, not because, again, the allegations were deemed insufficient to amount to ICC crimes, but actually because the principle, it determined that the principle of complementarity was satisfied. Meaning it found that domestic institutions were capable and willing to investigate and prosecute ICC crimes. And that is the example of Colombia that we've heard about in the beginning of this panel. So I'm going to circle back there, right? The ICC actually was engaged in Colombia. It opened a preliminary examination in 2014 regarding ICC crimes committed during Colombia's armed conflict. it maintained that preliminary examination open for 17 years. And after 17 years, in 2021, the prosecutor decided to close that examination. And it cited the country's domestic justice system, particularly the Special Jurisdiction for Peace, known in a Spanish acronym as the HEP, the JEP. And it cited to that system as able to genuinely investigate and prosecute those crimes. Now, as we've heard from Judge Lemaitre's presentation, that the HEP has a unique conditionality regime, which encourages perpetrators to confess their crimes and acknowledge their role in the conflict while holding out the possibility of criminal prosecution for those who fail to come forward. If perpetrators do come forward and recognize their role, contribute to the truth in a timely manner, they're eligible for alternative sanctions, such as community service type projects instead of prison. So the ICC's decision to close the preliminary examination has sparked various reactions among stakeholders. So many felt and feel that the ICC's engagement was critical at a time. It was critical in encouraging conversations about genuine accountability for conflict-era crimes. And in fact, instead of, like I said, opening a formal investigation, the prosecutor adopted a strategy it called positive complementarity, meaning working closely with Colombian authorities to ensure domestic proceedings met international standards. And in fact, over the years, it held multiple sessions, technical exchanges, and roundtable discussions with Colombian authorities and civil society. And many felt that, rightly so, rather than displacing national proceedings with international trials, the ICC's approach in Colombia reinforced domestic ownership of justice while encouraging alignment with Rome Statute obligations. However, the ICC's deference was not without controversy, right? Some organizations, victim organizations, felt the prosecutor did not provide enough or adequate enough reasons for closing the examination, and others continued to urge the ICC to monitor Colombia's progress in prosecuting crimes. More recently, the HEP issued its first restorative justice sentences, which impose non-custodial sanctions on former FARC commanders and former members of the military. We can elaborate on those decisions during the Q&A if time permits, but suffice it to say that even before most of us had the chance to read through the 600 pages or so of each ruling, strong and divergent opinions had already emerged. So some recognized that by offering these reduced non-custodial sentences in exchange for perpetrators' full acknowledgement of their crimes and contributions to the truth and reparations, the HEP was doing exactly what it was designed to do, right? It was helping to heal societal wounds, restore a sense of shared community values, and break cycles of violence. Others felt the sentences were perhaps too lenient, disproportionate to the gravity of the crimes, and ultimately threatened to undermine the credibility of the process. We can talk about those positions in Q&A, but I think the controversy highlights, as one colleague I think aptly puts it, the fine line between permissible restorative justice and impermissible impunity, and raises questions about how the ICC evaluates domestic efforts, justice efforts, particularly in complex transitional contexts. In sum, I would say that the ICC's varied responses to Latin American situations, ranging from a formal investigation in Venezuela to outright dismissal in other situations, have had significant consequences for domestic accountability efforts. While the court's engagement in Venezuela has offered a measure of hope, its decisions in other contexts have sometimes undermined local initiatives or reinforced some perceptions of impunity. Ultimately, I think the ICC navigates a very delicate balance, intervening when domestic systems fall short, but also exercising restraint when its support rather than direct intervention can genuinely strengthen national accountability mechanisms. And with that, I'll stop.
So this is for, I guess, all the researchers in the Colombia area. How do you think that the current administration's unilateral actions affect all of these efforts that you discussed? Go to the microphone. Oh, yeah. Hello. So my question is about Colombia, and how do you think the current administration's efforts, I guess unilateral efforts, to, I guess, bomb vessels in, let's say overall, how it will impact the efforts that you are discussing today, or what are the challenges that it presents?
Thank you for your presentation. I'm curious, a lot of the efforts, special jurisdictions, special investigations, special research, organized crime techniques and support, for a while have been supported by the US and other international donors from Europe or different parts of the component. I'm curious to hear from you all, both in terms of justice delivery, law enforcement, and any other government service or approach to organized crime or crime dynamics at the country level will maintain, or how will these efforts continue now that the traditional aid system has phased out, and how can we guarantee that locally led initiatives are as robust, as comprehensive, as are able to bring the issues to people's and decision makers' tables so that they are addressed properly and they have the mechanisms to support them. So I'm curious to hear what you see in this field. Thank you.
Sure. So the special jurisdiction for peace stems out of a global rules-based order that emerged out of the Second World War, together with the ideas of crimes against humanity and World War crimes are older than that. They still, the whole concept of international crimes flourished during that historic period. And the US always had an ambivalent position towards the idea of international crimes, most markedly in the negotiations around the ICC, while insisting on some issues, always choosing not only not to sign up, but also to pressure countries not to, in order to protect American immunity for their actions abroad. So the US always had an ambivalent position. And right now what's up for question, I guess, is whether or not the US is still going to back the idea of an international order based on diplomacy and rules and international law, or if it no longer sees a place for itself in it. More recently, the Security Council decided not to continue part of the mandate of the Commission, the UN Security Council Special Commission in Colombia that supports the HEP and that was supposed to monitor sanctions. But because of the Security Council's voting, which requires consensus, with the US being the lone country opposing continuing support. And I guess that's sort of a sign of the times. Thanks.
I would say that yes, the U.S. support has been always ambivalent, supporting very conventional or traditional approaches against organized crime, and also supporting some of the innovations we have described. I would try to think about the current situation as an opportunity to think about these strategies in a novel way, in which maybe there are not enough. Like, try to think about things with the same or with a lower level of resources can be fruitful in terms of, for example, focusing on the most damaging aspects of organized crime, and not focusing on by themselves on the illegal markets. So maybe there's some opportunities here to rethink about the prosecution and the law enforcement of organized crime. The prosecution in Colombia, at least, has almost 26,000 people, which is enormous for a Latin American country. But strategically, they have never been able to be successful against organized crime. They have a lot of operational successes, and that's partly due to the way the objectives are set. Yep. Rethinking these objectives can be an opportunity. Yep. Talking about the unilateral actions by the US, I would think it's very early to tell, but from a, let's say, a strategic point of view, I think it's more performative than effective in terms of hindering the illegal markets. Maybe there is a short-term decrease in supply from the Caribbean, which is not the majority of drugs that are coming to the US. But in the medium term, the market will adjust, and the routes will adjust. So it's more performative looking at Venezuela, I would think, and not the illegal markets themselves.
Okay, thank you. Sorry to come back to El Salvador, although it wasn't any question about El Salvador, but I want to leave a couple of messages and reflections about El Salvador. Taking into account what everybody said today. First of all, we need to keep working to promote accountability for what's happening in El Salvador right now. The ICC would be a mechanism, a long shot mechanism, but still a mechanism, and we have to continue working on different international human rights bodies. Second, in terms of this idea of creating a special commission, this is just an idea that we want to promote because we are aware there is no way that the judicial system in El Salvador could handle 90,000 cases. We need a lot of the Colombian experience, a lot, especially in relation to the discussions on prioritization and selection. So please, take with you this message, this idea, because we will need your expertise, your knowledge to bring it to El Salvador. And third point, in relation to funding, I mean, this is a big problem for everybody. I'm talking here as a practitioner, and of course it has affected us, the cutting in US funds, but we have to think out of the box and working together with other groups, create new coalitions, new alliances, even hiring people paid by different organizations, like have one person full-time, but the salary paid by different organizations. We are talking with our colleagues on this, what can we do to keep working on these new realities, that new reality. For us, the human rights ecosystem has changed forever. It's not going to be back. It's not going to be like it was last year. No, it has changed forever, and we need to adapt.
Well, I would like to do some brief comments. The first one is that I totally agree there's an opportunity here to talk about some innovations. From the United States, there has been some documents that talk about private investment in crime control. I think that can be feasible, especially when the Colombian government does not have the same amount of money or access to technology that criminals do. For example, Starlink or the non-tripulated, submarines that are going to Europe. I think there's an opportunity there. What we see is we need to sit down and talk. There can be divergent positions, but at the end we have the same drivers. Nobody wants criminals to do violent governance of their territories. We don't want people being submitted to drugs and what it means to public health and to life itself. And Colombia has been for a while a regional hub for a lot of things, justice, security. We train, thanks to what we have learned, now in Colombia, we train polices of many parts of the region, so that can keep on going on. And I think that we are looking to, in a short term, to some kind of regional alliance to be able to, have at least some kind of leverage to a regional alliance of criminals. So maybe some common prosecutors, common, that focus on, dismantling more than capturing or extraditing or.
Yeah, I agree with the panelists and don't have too much more to say other than I think the first question sort of points out that I think the leadership on accountability is not necessarily going to come from here, but that we will be looking to each other in the region to share experiences, Colombia, El Salvador, and other places, and to really focus on innovative, creative collaborations, partnerships, and funding streams to do it in the region. Thanks.
Okay, thank you.
Thank you. Thank you to the panelists and to all of you for coming. Hope you have a great ASC. Thank you.
Thank you. Thank you.